If it pleases the court, Your Honour, my name is Darben, D-A-R-B-E-N, initial CJ, and today I appear on behalf of the defendant. Your Honour, my client is charged with one count of murder under section 302 of the Criminal Code. Today I wish to make an application under section 590, capital A, subsection 2, subsection E of the Criminal Code. In relation to this application, I'll be tendering submissions of which will seek to have a piece of key Crown evidence excluded from trial on grounds that it was indeed obtained improperly and in contravention of law, thus warranting the exercise of the fairness and the public policy discretion. Your Honour, the defence is of the view that the record of interview in which my client made admissions that are key to the Crown's case is indeed admissible. However, the defence wished to submit that there is an argument in which the court may choose to exercise its judicial discretion, sourced from section 130 of the Evidence Act, to exclude said evidence. Your Honour, we submit that the police officers who were involved in obtaining the impugned evidence have acted in contravention of their duties under the Police Powers and Responsibilities Act, or the PPRA. Your Honour, the defence's submissions are seeking to have the evidence excluded on two grounds. Firstly, the record of interview should be excluded as a matter of the court exercising the fairness discretion derived from the case of Christie. And secondly, the defence submits that the evidence in question should be excluded as a matter of the court exercising the public policy discretion from the case of Ireland. In relation to our first submission, Your Honour, the fairness discretion as outlined in the case of Christie states that the evidence may be excluded where it operates unfairly on the defendant in the sense that it places them at risk of being improperly convicted. In order for this discretion to be exercised, the prejudicial effect of the impugned evidence must outweigh or substantially outweigh whatever probative value it may have. Your Honour, my client is a 15-year-old Aboriginal boy and therefore he is legally a child under Schedule 4 of the Youth Justice Act. It is paramount that these age and cultural factors be taken into account when questioning occurs. A failure to take these factors into consideration may have the effect of operating unfairly towards my client. The defence admits that the questioning police officers have in fact failed to take these factors into consideration. Section 421 of the PPRA states that the child must not be questioned until they have been afforded the opportunity to speak to a support person of their choice. Though my client's mother was present during questioning, the questioning should have been delayed until my client could speak with her. Moreover, it is unclear whether or not the officers gave my client a choice or whether they chose the support person for him. A similar obligation is found in Section 420 of the PPRA, which provides the same right for Indigenous persons, of which my client is an Indigenous person. In addition, Section 420 requires that Aboriginal legal aid must be notified of any Indigenous persons in custody. Your Honour, there is absolutely no record of any such notification being made. Because of these failures by the questioning officers, my client's admissions cannot be seen to have any substantial probative value. To quote Justice Brennan in the case of the Crown and Swaffield, if there's no probative force could be attributed to a confession, the warrant for its admission would be denied. For that reason, the courts have been cautious in admitting into evidence confessions obtained in circumstances of which throw doubt upon their reliability. Your Honour, it is clear that the prejudicial effect of my client's admissions substantially outweigh the probative value. The nature of his questioning brings into doubt the reliability of my client's admissions, and thus it would be extremely unfair to admit the record of interview as evidence, as the jury would be likely to give it much more weight than it truly deserves. In relation to the second submission, Your Honour, the island discretion allows for the court to exclude any evidence that was obtained improperly or illegally. As mentioned in the first submission, both Section 420 and 421 of the PPRA were not complied with by the questioning officers. No attempt to contact the Aboriginal Legal Aid Service was made whatsoever. This is a clear breach of the questioning officers' statutory obligations. The principles outlined in the case of Bunning and Cross dictate when evidence should be excluded as a matter of public policy. It is evident that the officers knew of their obligations under Section 420 of the PPRA as they told my client that they were indeed going to contact an Aboriginal Legal Aid Service representative. The fact that this did not happen is a reckless and deliberate breach of the law, and the conduct in question was simply the questioning officers cutting corners. There is no reasonable explanation at all or any pressing circumstances for why such a simple phone call could not have been made. Though the gravity of the charge against my client is very serious, the fact that the questioning officers were in contravention of the statute far outweighs the gravity of the charge. Your Honour, Section 7 of the PPRA states that it is Parliament's intention that police officers should comply with the Act and also whilst exercising powers and performing responsibilities under it. Section 5, subsection E of the Act states that one of the main purposes is to ensure fairness to and protect the rights of persons against whom police officers are exercising powers under the Act. Your Honour, the PPRA is quite clearly a strict statutory set of rules that police officers must follow meticulously. They're not merely just a set of guidelines. It is not acceptable as a matter of public policy for the questioning officers to engage in such conduct. Your Honour, admitting the record of interview of my client as evidence would render this kind of conduct acceptable and would undermine one of the main purposes of the PPRA and would also allow officers to flaunt the law in any way they'd like. Your Honour, that concludes the defence's submissions.